Dennis and I work with a lot of small businesses, both from a legal and financial planning perspective. One of the things I'm noticing, particularly with small to mid-sized businesses, is for estate planning purposes, they have everything, the business owner has everything taken care of by way of personal property, personal assets. But then there's a big question of, well, what do we do with the business, particularly if you're a sole shareholder or a majority shareholder? And one of the things that we can accomplish either through a trust or through amending operating agreements or bylaws is what happens to those shares when that person passes away. Have you dealt with those circumstances, Dennis?
Yeah, and typically they're not very happy circumstances because this isn't ever really set up at all in my experience.
One of the things that I like to talk with my small business owners is at some point, if things go the way you want, the business will become a going concern and you're going to have this thing. You don't want to have something worth multiple millions of dollars and not have any direction for what happens to it when you pass away, particularly if you're a sole shareholder or a single member LLC. We can incorporate provisions into the trust that would direct the trustee, for example, to offer shares to your family first before other participants or other shareholders or members in the LLC. So it's another component of estate planning that needs to be looked at because it's often forgotten until it's too late.
And if you have a successful small business, another aspect of this that rarely gets looked into is insurance planning, like key man insurance,
Correct.
Like buy-sell agreements, so that at the death of the owner, effectively there's liquidity to the point where shares can be paid out to whoever those people are.
Yeah, this could split off into a number of different episodes, but it's important that if you have a strong going concern that these issues are addressed before you pass away or before you become incompetent. You certainly could sell the business at any point, but if you're going to deal with it as an estate benefit or as estate property, we can put provisions into both operating agreements, bylaws, and or a trust so that different things are tripped or different requirements on the trustee are placed on them so that when you do pass away, the business just doesn't dissolve for lack of any direction.